Does that information become part of the record?
I assume so. Others can answer that better than me. I don't know how that process works to that extent. I'm sure they can answer.
Well, let me ask it another way. If you're going to use that information to make a determination about release or holding someone, shouldn't it become part of the record? And I asked the question because I'm told it doesn't.
You need to, with all respect, your fact ought to come from people who can give it to you. I can't give you that fact.
But I'm not asking you for the fact. I'm asking you, but you know the law, and you know how the law should work. I'm asking you, if that information is used to make a determination about whether or not someone is released, shouldn't it become part of the record?
I have no problem with that. I have no problem with that at all.
Judge.
Judge,
I didn't ask you if you had a problem. My question was...
Yes, I'm answering is yes.
My question was, as a judge, as someone I have the greatest regard for, I want your legal opinion. Shouldn't any information that is used to make a determination as to whether or not someone is released, shouldn't that information become part of the record?
I say yes to that. However, recognize there's always some information that may be about a person that may not be sufficient or such that it should be public. Because there's some information about people that deals with, like, health issues, for instance, that shouldn't be a part of a public document.
So it may be information that would be sealed for some reason so the general public can't get to it. But if a judge is using it to make a determination, it should be part of the record, shouldn't it?
If that information, again, based on information that can be in a public record, in a public document, yes. I'm saying yes.
Okay. Thank you.
Yes, ma'am.
I just wanted to thank you, Judge Johnson, for coming and speaking.
There's not one thing in the risk assessment that's private. I have one. I have a Keene Scott's, and I've released it to the press.
Looking at all 6 pages, the first section is a criminal history. The police, the judges, the DA, they're going to have that information. The 12 questions, again, can be filled out by anybody. The only questions they would have to ask are you working, or are you a student, where do you live, how long you live there? Everything else they already know. I don't think that the working or the student thing would hurt their case or hurt their issues with the DA or the sheriff. Going to the next section, it's asking where you live, what part of school you went through. I mean, are you in college? Things like that. It's not. There's nothing there that they don't already know or can't find out or don't care about. And then the last section, determine a person's financial situation to determine if they need a big bond, a small bond, no bond. Well, we know they're going to rate them low. So the next question is, should they get a free lawyer? But there's nothing in this Vera Institute of Justice risk assessment instrument that the court doesn't know already or can't find out on its own or just doesn't care about.
First answer Councilmember Gray's question from earlier that he asked to Judge Johnson. The answer to the question, I agree with Judge Johnson that the key information, putting aside some personal information that goes to the decision to detain or release a person, should be public record information. As you'll see when you hear, presumably in the report, we don't know the findings, so I don't know this, but the program was developed under the Criminal Justice Leadership Alliance in a collaboration with all of the system actors. And while we brought national best practices and data-driven approaches to that, we adjusted for the local culture, and in short, it was decided by the working group that the risk assessment reports would be presented to the DA, to the defense counsel, and to the judge, but not made a part of the public record, sealed or unsealed. I am more than happy to rethink that. That's not our decision. That was a decision of the group. I think philosophically speaking, I would prefer that every pretrial report be part of the public record.
My concern is a little bit more than philosophical. I mean, have you had lawyers discuss this issue and see whether or not it's perhaps constitutionally required that information that is used as a basis for making a determination about retaining or releasing a person should be part of the public record?
In some part. I mean, we've looked at jurisdictions across the country, and the majority of them do not make it part of the public record. And there are pieces of it that are federally barred from being made part of the public record or even given to defense counsel. For example, the NCIC report. But again, we believe the risk assessment report, those issues that go before the court, those factors that go before the court to guide them in their decision-making should be part of the public record, and we don't think there's a legal obstacle to doing so.
Well, my question was a little different from what you answered. I'm really not concerned about a survey of other districts. My question is, have your lawyers told you whether or not they think it is required to be part of a public record if the judge is using it as the basis of the decision whether or not to release a person? And that's not, is there a legal obstacle to putting it in the public records, but shouldn't it be in the public records?
It should. It should.